I want to speak a bit maybe preemptively, but I really do not think that the courts are going to find that the rules are unconstitutional or unlawful in any way, primarily because there were no rules before. So whilst the Constitution did indicate that there must be provisions made for the lawful and constitutional removal of heads of Chapter 9 institutions, those rules were not created by our legislature. Now the rules have been created, they've been drafted and deliberated, and they've been accepted. Now they exist, and they must be put into action where it is appropriate. And the panel that was appointed by our legislature to investigate whether there was a prima facie case against the public protector has found that there is one indeed. The rules are now in existence. They have been deliberated by our lawmakers. They must be used to make sure that whatever process is followed to remove the public protector and anybody else who comes after who is found to be guilty of misconduct or incompetence is removed in a lawful and constitutional manner. So I think that this is another delay tactic perhaps to try and delay the process. And we're already about 3 years into this process from the very first time the Democratic Alliance put a motion forward in the House.
Advocate Dalimpofu, who's representing Advocate Mkhwebane, is not sharing the view that you have espoused. He has said, and I quote, that it is a logical and legal impossibility, he says, for an impeachment process to go ahead against the public protector as the rules of Parliament prevent it. What could he be pointing to?
I do not know. The rules are very clear, they are concise, they are spelled out, they have been heavily deliberated upon. There's a process, a step-by-step process that's enumerated in the rules. I'm uncertain about which part of the rules might be considered to be unconstitutional. And from the reports that we've seen, he might be referring to the fact that this is kind of the narrative that the rules were created with the public protector specifically in mind. That could be what he's referring to. And perhaps as well, the retrospective application of the rules might be a point that will be raised by Council Mpofu. So those two might be the points he's referring to. But once again, I don't believe that those points, whatever arguments he has for those points, will be accepted by the court, simply because yes, of course, the rules were drafted after a number of incidents related to the current public protector. And I don't think that lawmakers imagined that we'd ever have to remove a sitting head of a Chapter 9 institution. We have yet to see it. And of course, there was an omission on the part of the lawmakers to not have these rules in place in the first place. But we live in a responsive society, a responsive democracy that should allow for those omissions to be addressed. Were Parliament not allowed to undo or rectify errors, then we would not have a functioning, healthy democracy.
And, you know, that perhaps might be even one of the reasons, the fact that these rules some may say, seem to have been crafted specifically for her with an agenda and an ulterior motive to have her removed and from her office and impeached.
I think, like what I have just said, it's important for us to note that these provisions are constitutionally mandated. So there was an omission, definitely an omission on the part of the legislature in terms of translating a constitutional imperative into legislature, into rules. That was an omission on the part of the lawmakers, which has now been rectified. And were the person being removed, for example, say the Auditor General or the head of the IAC, would we then say once again the rules are being crafted to remove one specific person? No. It's unfortunate that this is a narrative that has been created to kind of buttress whatever challenges the public protector is putting forward. But the rules have to have been made. They were required by the Constitution, and I think the timing is what is fueling this inaccurate narrative that the rules were created for her specifically. Because in the future, should we come to another situation where a head or an official of a Chapter 9 institution has been found guilty of misconduct or whatever constitutional requirements, the rules will then be used. They will be applied indiscriminately, equally, and the person will be given the same room that the public protector has been given to go to court and challenge them, to challenge their proceedings. We live in a democracy that allows an individual who occupies such a high office to challenge the rules. So we're just going to wait until the court hears the case and hands down judgment and hopefully proceed with a very open, democratic process.
There is another statement and 2 points actually that were made by Advocate Dalimpofu, and if you could just comment on those 2 separate points. One of them, he says that the rules of Parliament prohibit MPs from discussing the merits of cases that are before the courts. That is one. If you could comment on that, and on the back of that, the fact that Advocate Busisiwe Mkhwebane has no legal representation in Parliament. Is that not her right?
I'm going to answer your questions backwards. So the second question, yes, so there is no provision as yet in the rules for legal representation for an individual who is being impeached or accused of incompetence or misconduct. And I think when we look at the comments from members of Parliament during the deliberations of the rules, the appointment process does not require legal representation. The appointment process is one that is investigative. You make your representations as an individual, you're interviewed, and everything, including your CV, are considered holistically by members of Parliament. So the removal process itself is mirroring the appointment process, laying power back in the hands of those that appointed the individual concerned. So it seems as though they are mirroring the appointment process. It does not require legal representation. And as we have now we have passed the prima facie investigation that has found that perhaps there is prima facie ground for an impeachment process. We already have had some of our country's top legal minds evaluating the circumstances, looking at the evidence before us, evidence that's openly in the public. We have seen and heard the judgments. We have even recent ones from the Labour Court. We have another one from, I think it's USASA, SA, that has laid the path for, the argument for impeachment because of misconduct and incompetence. So I think the process of removal is mirroring that of appointment, where there is no legal representation necessary and a person is judged or evaluated based on the evidence that exists. The first question, the sub judice issue, I think that it's a very interesting argument that has been put forward by Advocate Dalimpofu, in the sense that normally, yes, when a case is before a court of law, you cannot discuss the merits thereof in any other space until judgment has been passed. And this is to ensure that there is a fair process, if there's a trial, a fair trial, one that is devoid of any influence from the outside. And I think because of the two parts of the matter before the court today, the second that was refused last year by the court, to say, then let's stop the proceedings and allow a court process to review the rules before anything proceeds, because there's a disjuncture in what's going on in Parliament and before the courts. I think it's a very interesting argument, and I'd be very interested to hear what the judges on the bench would say to that argument. It's a very unique situation in that you have part of the process, a part of the court application having been denied and allowing a process to continue in Parliament, and another part that links very heavily to the part that was denied before the courts today. So I don't have an answer, in the sense that I've never seen a situation like this before. It's a very interesting argument. It's very much founded in law, and it would be interesting to hear what the judges themselves will say, because this is a unique situation.
And unique in many fronts, it certainly is. Thank you very much for your insight this afternoon. That's Ms. Rebecca Sibanda, constitutional law expert.